The letter arrived at Ashbourne Park on the 14th of October, 1819, addressed to Lord Callum Ashbourne, 5th Duke of Hartwell, in handwriting that the receiving footman mistook for a clerk's precise, rapid, entirely without ornament. It was not from a clerk. It was from the Thorpe Asylum for Disordered Minds, situated 12 miles north of York, and it read as follows. My Lord Duke, it is my obligation to inform you that Miss Isolde Vane, formerly of Greymere Hall, Derbyshire, your late uncle Lord Edmund Vane's ward, and the designated beneficiary of the Vane estate, has been resident at Thorpe Asylum since the spring of 1816, committed at the instruction of Mr. Gerald Vane, her cousin, on grounds of mental instability following her uncle's death. As Mr. Gerald Vane has himself died intestate this past August, administration of the estate has fallen, by order of the Chancery Court, to the nearest remaining male relative of the Vane line, which the court has determined to be yourself. You are therefore requested to present yourself at Greymere Hall at your earliest convenience, to assess the estate's condition and determine the appropriate course of action regarding Miss Vane, whose continued maintenance at Thorpe Asylum must be decided within 60 days. Your obedient servant, Mr. Thomas Croft, Chancery Court Trustee. Callum Ashbourne read this letter 3 times. He was a man of 37 who had spent the last decade in a diplomatic post in Vienna and had returned to England the previous year to discover that the dukedom he had inherited was solvent, his London house was in good repair, and his social obligations were exactly as tedious as he remembered. He was not a man who startled easily. He had stood in rooms with Napoleon's generals and not startled. He had navigated the labyrinthine politics of the Austrian court without startling. This letter startled him. Not because of the estate. He cared little for the Vane estate, which his mother had mentioned once as a middling property with good farmland and an indifferent house. He had not known Edmund Vane well, a distant connection on his mother's side, long widowed, no children of his own. What startled him was the name, Isolde Vane. He had heard it exactly once, 3 years ago, in a letter from his solicitor, noting that a Chancery Court had placed the Vane estate in trust, pending the resolution of a lunacy inquiry. He had filed it away without further thought. There were, in England in 1819, a great number of lunacy inquiries, and he had not considered himself their keeper. He considered himself that now. He folded the letter. He called for his carriage. He told his valet to pack for a week in the north, which, given Yorkshire in October, required planning. He did not write ahead to announce his arrival. This decision would prove, in retrospect, to be the most consequential of the journey. The lunatic asylum system in Regency England was largely unregulated and deeply corrupt. Private madhouses, like the fictional Thorpe Asylum depicted here, operated for profit. They were paid per patient per week, which created a direct financial incentive to maintain commitments for as long as possible. The 1815 to 1816 Parliamentary Select Committee on Madhouses found harrowing conditions in many private facilities. Patients shackled to walls, kept in darkness, denied basic food and water. The reformer Samuel Tuke had established the York Retreat in 1796 as a humane alternative, but it served only a fraction of those committed. For a woman committed by male relatives for the purpose of seizing her estate, the asylum was not treatment. It was a cage. Greymere Hall sat at the end of a long drive lined with oaks that had been planted in 1720 and had since grown to a magnificence entirely inconsistent with the rest of the approach, which needed resurfacing. The house itself was a square Georgian building of honey-colored limestone, solid and unpretentious, with the particular quality of a house that has been well maintained by someone who cared about maintenance rather than spectacle. Callum's carriage arrived in the mid-afternoon. The sky over the Derbyshire hills was the specific grey of English late autumn, not threatening, simply committed to its own dullness. He expected an estate under the mismanagement of a court trustee. He expected overgrown gardens, a skeleton staff, windows with the blank look of rooms not in use. He did not expect smoke from 6 of the chimneys. He did not expect the kitchen garden, visible through a gap in the hedge, to be producing something he could not identify what, at this distance, but the rows were straight and the beds were turned. He did not expect the groom who appeared from the stable yard before the carriage had fully stopped to be young, well-dressed, and entirely composed. He did not expect the front door to open before he had knocked. Before we continue, kindly support the channel, please subscribe, and also like so that the story reach others. Thank you. Now let us continue. The woman who opened it was not what he had been imagining for the 12 miles from the last posting inn. He had been imagining someone diminished. Someone who had spent 3 years in an asylum and carried the marks of it. Someone who would need to be managed, arranged, restored to health, transferred to some appropriate guardian, and the whole business concluded within the week, so that he could return to London, and his calendar of obligations he found only marginally more interesting than this. The woman who opened the door of Greymere Hall was 30 years old, approximately 5 feet and 4 inches of contained competence, dressed in a dark blue wool working dress with ink on the left cuff. Her dark hair was pinned up, but not elaborately the hair of a woman who dressed herself with efficiency rather than ornament. Her eyes, which were gray and direct, completed an assessment of him in approximately 4 seconds. She said, "You are Callum Ashbourne, the Duke of Hartwell. You are 4 days earlier than the trustee's letter suggested you might arrive, which is either impressive or alarming. Come in. Mrs. Holt has just made tea." She turned and walked back into the house. Callum stood on the doorstep for a moment longer than was entirely dignified. Then he followed her. The drawing room of Greymere Hall was the drawing room of a house that was lived in rather than presented. There were books on the side table, not decorative books. Books with pages turned back at passages of interest, margins annotated. There were estate papers on the writing desk near the window. There was a second pen, recently used, and an inkwell without its cap, indicating someone who returned to work frequently, rather than leaving it to settle. There was tea. It was good tea, which in Callum's experience indicated either wealth or competence. Given the state of the estate as he understood it, he suspected competence. Isolde Vane poured it herself. There was no maid in attendance, which was either an economy measure or a statement. Given the woman, he suspected statement. "You are surprised," she said, without looking up from the teapot. "Most of them are. Most of the official persons who come to the house. The trustee comes once a month and is surprised every time to find it intact. The county magistrate came in July and was so surprised he sat in that chair for an hour, asking me to repeat myself." She looked up and handed him his cup. "You are, I think, more difficult to surprise than most. But you are still surprised." Callum considered this. "You are supposed to be at Thorpe Asylum," he said. "I left Thorpe Asylum in October of 1816, she said. 7 months after I arrived. You left." "I walked out," she said, with the precise simplicity of someone explaining a thing that is less complicated than others assume it to be. "On a Wednesday morning, while Dr. Hartwell was attending to another patient. The gate on the west side of the grounds is poorly maintained. It has been poorly maintained since at least 1814, based on the rust patterns. I had been studying it for 3 weeks. I walked out, found the road to Bakewell, and took the mail coach home. The room was quiet. Your cousin had you committed," Callum said. "Gerald," she said, and the name sat in the room like a stone dropped into still water. "Yes. He committed me 6 days after my uncle Edmund died. Edmund was kind. Edmund had provided for me in his will, the house, the estate income, a settlement that would have allowed me to live independently for the rest of my life. Gerald determined that this arrangement was inconvenient. He produced 2 physicians who had never met me, and a letter from a vicar who also had never met me, and I was committed to Thorpe Asylum on the grounds of—" She paused, and there was in the pause the particular quality of a woman who has had 3 years to achieve equanimity about something that does not deserve equanimity. Instability of mind following grief, manifesting as an inability to recognize the authority of those placed over her welfare. Callum put down his teacup. "That is not a medical diagnosis," he said. "No," she agreed. "It is a description of a woman who refused to sign over her uncle's estate without a fight. They called it madness. I called it property law. The term moral insanity coined by Dr. James Cowles Pritchard in his 1835 treatise, but circulating in medical discussion from the early 1820s, was used to describe behavior that deviated from social norms without obvious cognitive impairment. In practice, this allowed physicians to certify as insane any woman who behaved in ways deemed unfeminine, including managing finances, arguing with male relatives, or refusing to marry. The absence of cognitive deficit was not considered exculpatory. The presence of disordered will or perverse inclination was sufficient grounds for commitment. The woman had no legal recourse once certified. She told him the rest of it without drama. She had a talent for factual narration that Callum, who had spent 10 years in diplomacy, recognized as the mark of a mind that understood the difference between what had happened and how one felt about it, and had chosen, for strategic purposes, to report only the former. Gerald Vane had administered the estate for 7 months. In those 7 months, he had discharged 4 of the 8 tenant farmers, sold the breeding stock from the home farm, removed most of the household silver, and begun negotiations to sell the timber rights on the North Wood, negotiations that were stalled because the prospective buyer's solicitor had questions about the title that Gerald could not answer. In October of 1816, Isolde had walked in from the Bakewell mail coach, let herself through the back kitchen entrance with the spare key she had kept in her shoe throughout her asylum stay, dismissed Gerald's temporary housekeeper, sent Gerald himself a letter, informing him that she was home and would be speaking to a solicitor in the morning, and gone to bed. Gerald had come to the house the following day with a constable, intending to have her removed again. He had found the solicitor already there. This was, she explained, because she had written to the solicitor from Thorpe Asylum on 9 separate occasions over 7 months, and the solicitor, a Mr. Everett Graves of Bakewell, a man of 60 who had handled the Vane family's affairs for 30 years and did not enjoy being deceived, had been preparing a legal challenge to the original commitment for 5 of those months. He was waiting for me to get home, she said. He could not file the challenge without my physical presence and sworn testimony. So I got home. Gerald had retreated, threatening further action. Further action had not materialized, because Gerald had died in August of a fever that was, as far as anyone could determine, entirely organic and unassisted. The estate had passed to Chancery, and now a duke had arrived in her drawing room. She looked at him across the tea tray, with the measured attention of someone who was now calculating the next obstacle. "What do you intend," she said, "to do?" Under English law in 1819, when a woman was declared legally incompetent through a lunacy inquisition, her property passed to a court-appointed committee, typically a male relative or solicitor, who was supposed to manage it for her benefit. In practice, this oversight was minimal. Chancery Court trustees were notoriously slow, underfunded, and stretched across dozens of cases. An estate under such an arrangement could be stripped bare before any official intervention occurred. The legal mechanism to challenge a lunacy inquisition was called a traverse, a formal challenge that required the alleged lunatic to appear before a jury and demonstrate their sanity. This process was expensive, grueling, and by no means guaranteed to succeed, even for a person in complete possession of their faculties. Callum spent the following 2 days examining the estate with the focused attention of a man who had spent a decade assessing the conditions of foreign courts for the British government, and had transferred those skills, without particular effort, to the assessment of a Derbyshire property under legal siege. What he found was this: the house was in good repair. The roof had been patched in 2 places recently, and well. The kitchen garden was producing a late-season yield. The remaining 4 tenant farms were operational, their rents current. The home farm had been restocked, not with the quality of livestock Gerald had removed, but with what could be afforded. The account books, which Isolde produced without being asked, were impeccable, double entry, clearly annotated, with a running commentary in her handwriting that noted every decision made, when it was made, and why. These were not the account books of a madwoman. These were the account books of a trained estate manager, which was what she had, in effect, become self-taught from her uncle's library, over 3 years of necessity. "Who taught you double-entry bookkeeping?" he asked, on the second morning, standing at her desk and examining the ledger for the previous quarter. "Pacioli," she said, without looking up from the letter she was writing. "Summa de arithmetica. My uncle had a 1523 edition. The Latin is not difficult if you have had a classical education, which my uncle insisted on, to the considerable confusion of his neighbors. Callum looked at her. She was writing a letter to a seed merchant in Derby about spring planting. She was writing it with the brisk efficiency of a woman who wrote several letters a day and did not consider any of them remarkable. The estate, he said carefully, is in better condition than I expected. It is in better condition than it was in 1816, she said. Gerald's 7 months set it back approximately 4 years. I have recovered 2 of those years. I expect to recover the other 2 in the spring, assuming the Northfield responds to the lime treatment I applied in September. A pause. You applied lime to a field yourself? I supervised, she said, with the trace of something that on another face might have been amusement. I drew the diagrams. The men did the carrying. I am not entirely impractical about the division of labor. On the second evening, he walked the grounds until dark, which was a thing he did when he needed to think without the architecture of a room shaping his thoughts. The North Wood stood at the edge of the property, 30 acres of mature oak and ash that Gerald had nearly sold. The timber was worth considerable money. Isolde had blocked the sale through her solicitor, citing irregularities in Gerald's authority to dispose of attached estate assets. The Chancery Court had placed the timber rights in suspension pending the trust resolution. He stood at the edge of the wood and looked back at the house. 6 chimneys smoking. The kitchen garden neat in the fading light. Lamps in the study window, which was her study now. Practically speaking, she had appropriated it the way capable people appropriate spaces, not through declaration, but through simple, continuous use, until the space remembered no other occupant. He had come here to assess a property and make decisions about a woman he had expected to find broken. He had found an estate and a woman who had both been broken and had declined the condition. The question, the legal question, which was the only question he was technically here to answer, was what to do about it. He already knew what he wanted to do about it. He was not yet certain she would permit it. The letter arrived on the 3rd morning. It was addressed to the Duke of Hartwell, care of Greymere Hall, which meant it had been sent by someone who knew he was there and who had moved quickly. It was from a solicitor in London named Aldous Pemberton, representing the interests of a Mr. Frederick Hale, who described himself as a distant connection of the Vane family and the holder of a note of debt £3,000, dated 1814, bearing the signature of the late Lord Edmund Vane. The letter was polite, precise, and a threat. Mr. Hale was prepared, it stated, to assert a claim against the Vane estate in satisfaction of this debt. He was furthermore prepared to raise, before the Chancery Court, a renewed question of Miss Isolde Vane's legal competence to administer an estate. Given her history of the letter, use the phrase, documented instability, and the irregular nature of her departure from medical supervision. The letter gave them 14 days. Callum put it on the breakfast table in front of Isolde without comment. She read it once. She set it down. She said, Frederick Hale. I wondered when he would appear. You know him. He was Gerald's business associate. They had arrangements that did not bear close examination. I documented several of them in the spring of 1817, when I was going through the estate papers Gerald had left in the study. She reached for her tea. The £3,000 note is real. Edmund did borrow that money. What is not real is the interest Hale has added to it, which doubles the sum, and the legal standing of the note following Edmund's death and the subsequent chancery proceedings, which my solicitor believes extinguished it. You believe. Mr. Graves believes, she corrected. He has studied the question for 18 months. His opinion is that the note cannot survive the trust dissolution. Hale knows this. This, she touched the letter with one finger, briefly, the way one touches something unpleasant to confirm it is there, is not a legal claim. It is a pressure tactic. To what end? She looked at him directly. To make you uncomfortable enough to settle the estate quickly and walk away. If you settle quickly, he gets something. If you examine it properly, he gets nothing. He is betting on administrative impatience. Callum considered this for a moment. He has chosen the wrong duke, he said. Isolde's expression did not change. But something behind it shifted a minute recalibration. The kind that happens when a calculation one has been running produces a different result than expected. Yes, she said, after a moment. I am beginning to think he has. A traverse was the legal mechanism by which a person certified as a lunatic could challenge their certification before a common law jury. Under the procedure established by the Lunacy Act, a traverse required sworn testimony from the alleged lunatic, supporting statements from witnesses who had direct knowledge of the person's behavior, counter-evidence challenging the original medical certifications, and a fee that was, in 1819, approximately £40, a significant sum that placed the procedure beyond the reach of most committed patients. The jury's verdict was legally binding. If the jury found the traverse successful, the certification was voided and the person's legal identity fully restored. If unsuccessful, the person could be recommitted with no further legal recourse for 5 years. Mr. Everett Graves arrived from Bakewell on the 4th morning, in a gig that had seen better decades, wearing a coat that had seen better years, carrying a leather satchel that appeared to contain the better part of a small library. He was 62 years old, with the face of a man who had spent his professional life in the company of difficult legal situations and had developed a particular economy of expression. In response, he said what was necessary, precisely, without preamble, and stopped when he was finished. He shook Callum's hand, looked at him for 3 seconds, and said, "Good. You're not an idiot." I was concerned. He then sat down, opened his satchel, and proceeded to lay out the legal landscape with the methodical clarity of a surveyor mapping difficult terrain. The traverse of Isolde's original lunacy certification had been filed with the Chancery Court in January of 1817. It had been proceeding slowly, at the court's pace, which was glacial ever since. The original certifying physicians had been contacted. One had died. The other had, on being presented with Graves's counter-evidence, declined to defend his original assessment in terms that amounted to a tacit retraction. The vicar, whose letter had been used as supporting evidence, had provided a statement acknowledging that he had signed the letter as a favor to Gerald Vane and had not, in fact, possessed any direct knowledge of Isolde's mental state. The traverse was, in Graves's assessment, sound. It was also, in Graves's assessment, in danger. Hale's letter, Graves said, setting it on the table with the tip of one finger, is the problem. Not the debt claim. I agree with Miss Vane that the note is legally extinguished. The problem is the renewal of the competency challenge. If Hale can get a Chancery Justice to hear that application before our traverse is concluded, he can suspend the traverse proceedings and reset the clock. How long would that take? The suspension? If granted, 2 to 3 years. The room was quiet, and in that 2 to 3 years, Callum said slowly, the estate would require a male trustee, Graves said. Hale would apply to be appointed. The court is short-staffed and inclined toward consent orders. He would almost certainly succeed. Callum looked at Isolde. She was sitting with her hands flat on the table, not clasped, not ringing, simply flat, the way a person places their hands when they are keeping very still on purpose. How do we stop it? Callum said. Not a question. Graves looked at him for a moment. There is one mechanism that would remove the competency challenge as a viable tactic permanently, he said, and simultaneously resolve the trust disposition without requiring the traverse to conclude. A pause. A marriage settlement, Callum said. He had reached the same conclusion approximately 60 seconds before Graves said it, and had spent those 60 seconds deciding whether he was prepared to say it aloud. Between Miss Vane, Graves said carefully, and a person of sufficient legal standing to render the competency challenge moot. A married woman's legal status is her husband's. If her husband attests to her competency, then no separate challenge can be raised, Callum said. He looked at Isolde. She was looking at the window. No, she said. The word landed with the particular weight of a decision that had been ready before the question was fully asked. She did not explain herself at the table. She excused herself, with the even courtesy she apparently applied to all situations, regardless of temperature, and went to the North Library, which was a room on the upper floor that was clearly hers in the way rooms become yours. When you have spent years in them reading and thinking. Callum followed her. This was not universally welcomed. She turned when she heard his footstep. I said no. You said no to a legal mechanism, he said. I would like to understand why. Because the last time a man controlled my legal status, I spent 7 months in a room with bars on the window. The silence that followed was absolute. He stood in the doorway of the North Library and felt the weight of it, the specific gravity of a thing, said, without embellishment, without accusation, simply as fact. She had not raised her voice. She did not need to. That is fair, he said. She looked at him. I am not asking you to trust me, he said. I understand that trust is not something I have earned, or that you have reason to extend. What I am asking is that you allow me to make a legal argument that I think is worth examining. She waited. A marriage settlement, he said, does not have to operate the way you are imagining it. The settlement is a document. Documents can be specific. They can stipulate what a husband may and may not do with his wife's estate, her income, her autonomy in detail, with enforceable conditions. It is not common, but it is legal. And a settlement constructed by a solicitor of Mr. Graves's caliber, specifying that the wife retains sole administrative authority over Greymere Hall and all associated. You are describing a document that would require a man to bind himself legally to something the law does not require him to honor. No, he said. I am describing a document that would require me specifically to honor it. And I am a duke, which means that a solicitor, a judge, or a court of law looking at a settlement specifying the rights of the Duchess of Hartwell over her own estate would be looking at a document backed by a title and a legal record that is rather harder to dismiss than a letter from a doctor who never met you. She was quiet. You have been managing a loan for 3 years, he said, against a system that has tried, with considerable resources, to take everything from you. I am not asking you to stop managing a loan. I am asking you to consider adding one more instrument to your arsenal. Another silence. This one had a different quality. Not closed, but assessing. Why, she said, would you do this? He had expected this question. He had been considering his answer since approximately the moment he had stood at the edge of the North Wood the previous evening. Because what was done to you was wrong, he said. And I have been in a position, for the past 3 years, to have done something about it, and did not. Because I did not know. I know now. I do not intend to leave without addressing it. She looked at him for a long time. That is an insufficient basis for a marriage, she said. I agree, he said. Which is why I am not proposing one. I am proposing a legal mechanism. Those are different things, and I suspect you are more than capable of distinguishing between them. The ghost of something not quite a smile, but its quieter sibling moved across her face. Sit down, she said. We are going to read the settlement terms together before I agree to anything. He sat down. Bow Street runners, the forerunners of the modern police, operating out of Bow Street Magistrates' Court in London, were available for hire by private individuals in the early 19th century. They investigated crimes, recovered stolen property, located absconded debtors, and served legal documents. For a fee, a duke could engage a runner to investigate a private individual's financial dealings. The information obtained was not necessarily admissible in court, but it could be presented to a chancery justice as grounds for dismissing a legal application, or used as leverage in private negotiation. The Bow Street runners were disbanded in 1839 when the Metropolitan Police was established. On the morning of the 5th day, while Isolde and Graves worked through the settlement terms in the North Library, Callum wrote 3 letters. The first was to his own London solicitor, Mr. Whitmore, instructing him to begin an immediate examination of Frederick Hale's financial dealings over the previous 5 years, with specific attention to any involvement with the late Gerald Vane, any previous applications to Chancery Court in relation to debt recovery, and any current legal proceedings in which Hale's name appeared. The second was to a Bow Street runner named Silas Croft, no relation to the trustee whom Callum had employed during a previous matter involving a forged diplomatic document in 1814, and who had proved both competent and discreet. The third was to Aldous Pemberton, Hale's solicitor, acknowledging receipt of his letter and informing him that the Duke of Hartwell would be happy to discuss the matter at a meeting in London at a date to be determined, and that he looked forward to a thorough examination of the documents supporting Mr. Hale's claim. The third letter was the important one. A solicitor receiving that letter from a duke would understand immediately that the matter was being taken seriously, that it was being escalated rather than managed, and that his client's position was about to receive more scrutiny than it was prepared for. Pemberton received the letter on the 8th of October. He went immediately to Hale. Hale, according to the runner's subsequent report, spent 20 minutes in agitated conference with Pemberton, followed by 40 minutes alone, followed by the dispatch of a new letter. This new letter arrived at Greymere Hall on the 10th. It proposed, in tones considerably less assured than its predecessor, a private settlement. Hale would drop his debt claim and withdraw the competency challenge application in exchange for £1,500, and an acknowledgement from the Duke of Hartwell that the original note had been a valid obligation. Callum read this letter at the breakfast table. Then he read it again. "He is frightened," Isolde said, from across the table. She had read it at the same time, without asking permission, which was something he had ceased to find surprising around the second day. "Yes," he said, "your runner found something." "He found several things," Callum said. "Hale has 3 active debt proceedings in Chancery against other estates. In 2 of those cases, the debt notes bear signatures that 2 different solicitors have independently characterized as, he chose the word carefully, irregular." Isolde set down her toast. "He forges debt notes." "He forges debt notes," Callum confirmed. "Or he procures forgeries. The distinction may be academic at this point." Then Edmund's note. "I cannot yet prove it, but I believe so." She was quiet for a moment. Then, "He did this to other families. Not just mine." "Yes." Another pause. When she spoke again, her voice had the particular quality of someone who has spent 3 years being careful about what they said and has just decided to be less careful. "I want him prosecuted," she said. "Not settled with, not paid off, prosecuted." Callum looked at her. "That," he said, "will take longer, and be considerably more unpleasant." "I know," she said. "I still want it." He picked up his pen. "Then let us write to the runner." The lunacy traverse proceeding was one of the few legal contexts in which a woman was required to speak on her own behalf. And even here, her testimony was filtered through the interpretation of the jury, all of whom were male. The procedure required the petitioner, the woman being re-examined, to appear before a special jury convened under Chancery authority, answer questions put by both her own counsel and opposing counsel, and demonstrate through her responses that she was capable of managing her own affairs. In practice, juries were often swayed by appearance and composure, rather than the actual content of testimony. A woman who appeared excitable or emotional during the proceedings was more likely to be found incompetent, regardless of the quality of her actual evidence. The cruel irony was that demonstrating the very self-control that indicated sanity required a performance of femininity that was itself constrained by the expectations of a male-dominated room. The traverse was heard on the 14th of November in York, before a jury of 12 men who had, collectively, never considered the question of female intellectual capacity in any rigorous depth, and who were not particularly planning to start now. Callum watched from the gallery. Isolde sat before the jury in a grey wool dress, not fashionable, not ornate, entirely composed. Graves sat beside her. The opposing counsel, a young man hired at the last moment by Hale's lawyer, who had by now largely understood that Hale's position was not strong, had the expression of someone who had been handed a case by a senior colleague and was only now discovering why the senior colleague had been so willing to part with it. The questioning began. Opposing counsel opened with the medical record from Thorpe Asylum. He read the certifying physician's assessments into the record, with the careful pronunciation of a man reading from a document he hoped would do the work for him. He described, at some length, the documented instances of agitation, refusal of authority, and disregard for proper management. Then he asked Isolde to describe, in her own words, the circumstances that had led to her commitment. She described them. She described them with the same factual precision she applied to estate accounts. Dates, names, specific actions, their legal implications, their practical consequences. She described Gerald Vane's methods, the original certification process, the 7 months at Thorpe, the walkout through the West Gate, and the subsequent 3 years of estate management, with reference to the account books and correspondence that Graves had entered into evidence. She spoke for 45 minutes. She did not raise her voice once. She did not weep. She did not perform distress or perform composure. She simply reported, with the clear-eyed directness of a woman who had spent 3 years being told that what she knew to be true was not true, and had kept records of it all, in case anyone ever asked. Opposing counsel's cross-examination lasted 11 minutes. It produced nothing useful for his client. Graves's additional witnesses were the second certifying physician, who confirmed under questioning that he had examined Isolde for a total of 20 minutes and had based his assessment largely on Gerald Vane's characterization of her behavior. The vicar, who repeated his written retraction, and a woman named Mrs. Sarah Thorne, formerly head housekeeper at Greymere Hall, who had been dismissed by Gerald in 1816 and had subsequently provided a statement attesting to Isolde's character and conduct both before and after Edmund Vane's death. Mrs. Thorne was 80 years old and said, among other things, "I worked for the Vane family for 41 years. Miss Isolde managed her uncle's accounts from the age of 18 because his eyesight was failing and he trusted no one else. If that is madness, this jury wants examining." There was laughter in the gallery. The foreman of the jury suppressed it with a look that suggested he agreed with it. The jury deliberated for 1 hour and 20 minutes. The traverse was upheld. Isolde Vane's lunacy certification was formally and permanently voided. Her legal identity was restored. Her estate was confirmed as her own, under her sole administration, to be managed as she saw fit, with no requirement for male oversight or chancery trusteeship. Callum was waiting outside the courtroom when she came out. The November sky over York was the color of cold pewter. Graves was behind her, looking satisfied in the restrained way of a man who does not permit himself more than that. She stopped in front of Callum. She did not say anything immediately. She was doing what he had come to recognize as her standard practice upon receiving significant information, processing it fully before speaking, which was a discipline he admired more each time he observed it. Then she said, "Thank you." It was 2 words. They carried, he thought, approximately 6 years of weight, and she had said them without flinching from any of it. "Graves did the work," he said. "Graves kept me in legal ammunition," she said. "You made the ammunition usable. There is a difference." They walked out into the pewter-gray afternoon, and the cold air had the particular sharpness of the north of England in November. And it was, he thought, one of the most purely clarifying things he had ever felt. Forgery of legal documents in Regency England was a felony under the Forgery Act of 1803, punishable by death, though in practice. By the 1810s, judges were increasingly commuting death sentences to transportation to the Australian penal colonies for 14 years. The crime of obtaining money by false pretenses was separately codified and carried sentences of up to 7 years transportation. A man convicted of both offenses simultaneously would face the full weight of the law and the social consequences. The destruction of professional reputation, the ruin of family name were often considered more devastating than the legal sentence. In an era before formal investigative police, prosecution of financial crimes depended heavily on private investigation and the willingness of victims to pursue matters through the courts, which was expensive, time-consuming, and socially uncomfortable. Most victims settled rather than prosecute. Isolde Vane was not most victims. The prosecution of Frederick Hale proceeded through the winter and into the spring of 1820. It was not simple. Legal proceedings in England in 1819 were not simple. And this one had the additional complexity of requiring documentary evidence of forgery across multiple cases involving parties who had varying degrees of willingness to come forward. What made it possible was the runner's work, Callum's connections, and Isolde's documentation. The documentation was, in the end, decisive. She had been collecting evidence of Hale's dealings since 1817, when she had found, in Gerald's papers, a series of letters that she had not understood at the time, but had copied and filed in the North Library, on the grounds that anything Gerald had done was worth keeping a record of. 3 of those letters directly implicated Hale in the construction of fraudulent debt instruments. 2 named the forger a man in Coventry, who had been producing high-quality debt notes for provincial solicitors for a decade, and was, upon the runner's arrival, considerably more forthcoming than might have been hoped. Hale was arrested in March of 1820. He was tried in June. He was convicted of forgery and obtaining money under false pretenses, and was transported to New South Wales in August. His solicitor Aldous Pemberton was separately censured and struck from the rolls. The 2 other families whose estates had been targeted by Hale received, through Graves's coordination, documentation sufficient to challenge the debt notes against them. Both challenges succeeded. On the day the verdict was announced, Callum was at Greymere Hall. He had been spending a considerable amount of time at Greymere Hall, ostensibly managing the administrative requirements of the trust dissolution and the settlement preparation, which were by March substantially concluded, and which did not require anything like the frequency of his visits. He was in the South Garden when Graves's letter arrived. Isolde came out to find him. She handed him the letter. He read it. He looked at her. Her expression was the expression of a woman who had just received confirmation of something she had pursued. Through 3 years of asylum, 3 years of precarious legal independence, a fraudulent debt challenge, a traverse proceeding, and a criminal prosecution, and who was now standing in the South Garden of her estate, in the March light, with the whole of it resolved, and who found, perhaps to her own surprise, that her eyes were not entirely dry. She did not move to conceal this. She simply stood with it, the way she stood with everything directly, without performance. "It is done," she said. "It is done," he said. The South Garden smelled of turned earth, and the particular freshness of March in Derbyshire, cold and green, and beginning. The North Wood was bare against the sky. The house stood behind them, 6 chimneys not yet lit at this hour, and the kitchen garden waiting for the spring planting, and the account books on the desk in the study with the coming year laid out in Isolde's precise hand. He had come to Greymere Hall to assess an estate, and decide the fate of a woman he had expected to find ruined. He had found, instead, the woman who had refused to be ruined, and the estate she had rebuilt from the shell of what ruin had left, and the 3 years of careful, irrefutable evidence she had assembled against the people who had tried. He had found, in other words, the most difficult and the most interesting person he had encountered in 37 years, and he was aware that the administrative reasons for his continued presence at Greymere Hall were increasingly implausible. The marriage settlement was signed on the 17th of April, 1820, in the North Library at Greymere Hall. With Graves as witness and the afternoon light coming through the tall windows onto the desk, where Isolde had spent 3 years keeping records of a world that had tried to tell her she did not exist. It was not a conventional settlement. It was a document of some 32 pages, which was unusual. It specified, in terms that Graves had drafted, with the precision of a man who had waited 60 years to write something of this consequence, the following: that Greymere Hall and all its associated lands, farms, timber rights, income, and movable property were the absolute and exclusive property of Isolde Vane, Ashbourne, Duchess of Hartwell, to be managed at her sole discretion, that the Duke of Hartwell held no claim on any portion of the Greymere estate now or in the future, that the Duchess retained the right to enter into all contracts, employ all staff, manage all financial dealings, and make all decisions regarding the estate without reference to her husband's approval, that in the event of the Duke's death, the Duchess's rights were entirely unaffected, that in the event of the Duchess's death, the estate passed to her own designated heirs rather than to the Duke or any Ashbourne interest. It was, Graves had told Callum privately, approximately as far from a conventional Regency marriage settlement as it was legally possible to get, while remaining valid under English law. Callum had read every page and signed every page without amending a syllable. After the signing, Graves shook both their hands, folded his copy of the settlement into his satchel, noted that the spring planting looked well, and drove back to Bakewell. This was, Callum had come to understand, Graves's characteristic mode. He appeared when needed, performed what was required with complete competence, and removed himself when his presence was no longer useful. Isolde was standing at the north library window. Outside, the Derbyshire hills were beginning to green, and the home farm was visible in the middle distance, and somewhere in the north wood, a bird was making an argument. "You did not have to include the inheritance clause," she said. "The settlement was sufficient without it." "I know," he said. "It ties your hands considerably." "I know that too." She turned from the window. "You are not a man who ties his own hands carelessly," she said. "No," he agreed. "I am a man who spent 10 years in diplomatic service making careful calculations about risk. And my calculation," he paused, and this pause had, in it, the quality of a man who has been precise about language his whole life, and is being precise now, in the most important context he can recall, is that anything constraining me from a claim on this estate is a useful demonstration that I came here for reasons other than the estate. She was quiet. "What did you come here for?" she said. It was the first time in 4 months that she had asked him a question that was not about law or estate management or the Hale proceedings. It was the first time in 4 months that she had asked him anything that required an answer about himself rather than a situation. "I came to collect an inheritance," he said, "and I found you," which was not what I was looking for. But then, the most significant things one finds are rarely what one was looking for. In my experience, she looked at him. She looked at him with the gray, direct eyes that had assessed him in 4 seconds on the doorstep in October, and had been, in their quiet, ongoing way, assessing him ever since, not with suspicion now, but with the same attention she gave to anything she considered worth understanding. "You are describing the situation with considerable restraint," she said. "I have been trying," he said carefully, "not to make you feel that the legal protection I offered came with conditions." "It did not," she said. "I know that." A pause. "I also know," she said, "that you have been finding reasons to stay at Greymere Hall for 4 months, and that the most recent reason reviewing the spring planting schedule with the head farmer was so transparently constructed that even the head farmer noticed. Callum thought about this. "He mentioned it to you," he said. He said, and I am quoting, "The Duke doesn't need to be here for this, ma'am, but I won't say anything if you won't." There was a long silence. Then, for the first time in 4 months, Callum Ashbourne laughed properly, without restraint. The laugh of a man who has been conducting himself with enormous propriety and has just discovered that his efforts were entirely transparent to everyone in the vicinity. Isolde watched him. And then, quietly, she laughed too. It was, he thought, the first time he had heard her laugh, and it was nothing like the carefully managed composure she wore the rest of the time. It was open and real and brief, and then it was gone. But it had been there, and he had heard it, and that was enough. "I would like," she said, when the laughter had settled, "to know you better, on terms that are separate from legal proceedings and estate emergencies." "Those terms," he said, "are entirely satisfactory to me." The account books for the year 1820 were, by any reasonable assessment, exceptional. The Northfield had responded beautifully to the lime treatment. The home farm had achieved a breeding yield that placed it in the top quarter of comparable Derbyshire operations. The timber rights on the North Wood, now freed from Gerald's abortive sale negotiations, had been let on a managed basis to a local mill that was responsible, understood sustainable forestry, and paid its contracted rates on the first of every quarter without requiring a letter. The 2 other families affected by Hale's forgeries had, through Graves's coordination, received full restitution. Graves had been approached by a 3rd family, in Lincolnshire, who had heard something of the matter. He had taken their case. Callum was in the North Library when Isolde came to find him. He had been spending a great deal of time in the North Library, not because he had run out of legitimate reasons to be at Greymere Hall. They had been married since the previous June, quietly, in Bakewell, with Graves as a witness, and no guests who had not specifically asked to attend, but because the North Library was the room she was most frequently in, and he found, without particular surprise, that the rooms she was in were the rooms he wanted to be in. She was carrying a letter. She set it on the desk without comment. He read it. It was from the Parliamentary Select Committee on Lunacy Law Reform, which had been constituted in the previous session at the recommendation of several reformers and one particularly vocal member of the Lords, who had been following certain high-profile lunacy traverse cases with what he described as professional concern. The committee was gathering evidence. It wished to include testimony from persons who had been subject to the lunacy system and could speak to its conditions and consequences. It was addressed to the Duchess of Hartwell. Isolde sat down. She sat in the chair at the North Library desk, her room, her house, her estate, and looked at the letter. "I have been writing to reformers for 2 years," she said, "since before the Traverse. I wrote to the York Retreat. I wrote to a woman in London who has been corresponding with Tuke's colleagues about reforming the certification process. I did not expect it to produce a parliamentary inquiry quite this quickly." "You have been building toward this," Callum said. "Not a question. There are women in asylums right now," she said, "on the same grounds they used for me. And Gerald is dead, and Hale is transported, and I am here. And they are not. And if there is a committee that will hear me—" She stopped. She pressed her lips together briefly, not with emotion held in, but with the particular determination of a woman deciding, once again, how large to make a thing she had decided to do. "Right back," Callum said. She looked at him. "Right back today," he said. "You have the testimony. You have the documentation. You have 3 years of account books that constitute a rebuttal to the entire theoretical basis of the certification system. Write back today, and tell them you will appear whenever they are ready." She looked at him for a long moment. "You are going to come with me," she said. "Not a question." "If you want me to," he said. "I want you to," she said. She opened the desk drawer and took out a clean sheet of paper. She uncapped the inkwell. She picked up her pen. Outside the North Library window, the Derbyshire hills were in full April green, and the North Wood was leafing into the particular tender brightness of English spring, and the home farm was active below the ridge, and the kitchen garden was planted and waiting, and the account books for 1821 were open on the side table with the coming year laid out in Isolde's precise, intelligent, entirely undisordered hand. She began to write. The world of this story was real. In Regency England, the commitment of inconvenient women to private madhouses was not exceptional. It was a mechanism available, affordable for those with means, and almost entirely unaccountable. The women committed were not, in the main, mentally ill. They were troublesome. They contested wills, refused marriages, managed their own property, read the wrong books, or simply said no to men who were unaccustomed to being refused. The law provided no protection and no remedy that was within the practical reach of a woman committed without resources. The reform movement depicted in this story's epilogue was also real. Samuel Tuke and the York Retreat, the 1815 to 1816 Parliamentary Select Committee on Madhouses, and the gradual legislative reform of the lunacy system across the 19th century were genuine historical developments, driven by genuine reformers. The Lunacy Act of 1845 finally established proper independent oversight of asylums 26 years after this story is set. The women who were locked away in the years between did not, in the main, have a duke arrive at their door. Some of them did what Isolde did. They found the weak gate, watched the rust patterns, and walked out on a Wednesday morning. We do not know most of their names. We should. If this story moved you, please subscribe and share the story. If you found yourself holding your breath in the Traverse Room, or in the North Library in October, or at the South Garden in March, tell me in the comments where you were listening from. And if you know someone who needs to hear a story about a woman who refused to be erased, share it. These stories are for all of us.